The mindset of our child protection system is that children don't lie and can't be mistaken about sexual child abuse. But what happens when there's a false allegation during divorce or separation between parents? Divorce is a life-altering experience for a man and woman. And when divorce includes children and high-conflict litigation, the legal battle can turn into full-blown war. When the gloves come off and punches are thrown, allegations surface, including heinous and reprehensible allegations. Nobody likes a child abuser, and especially someone who would sexually violate or exploit society's most vulnerable and precious resource, our children. Yet, contentious divorces do include one parent accusing the other of child abuse, even child sexual abuse. Some allegations are true. Many are unfounded or even false. It's been called divorce's atomic bomb, aka the ultimate weapon, and that's the false allegation of child sexual abuse. In 1987, psychologists Blush and Ross from Michigan called the high-conflict divorce that contained unsubstantiated child sexual abuse complaints SAID, or sexual allegations in divorce. He said, she said, and what a child said. Hearsay, by definition, is an out-of-court statement made for the truth of the matter asserted and is, generally speaking, legally inadmissible in court. But Rule 803 provides exceptions to the hearsay rule, and one of those exceptions is the excited utterance or outcry from an alleged child victim who's been sexually abused. In other words, if the child accuses a parent of sexually inappropriate behavior, even if there's no forensic medical evidence to corroborate the child's disclosure, the accused can be arrested, prosecuted, and, if convicted in criminal court, face possible life in prison and lifelong sex offender registration. And the possible wounded innocent can face termination of his or her parental rights in juvenile court. Sexual allegations in divorce cases, or SAID cases, represent the most egregious and acute form of parental alienation, which is psychological or mental child abuse. SAID cases involve preschool children, usually ages 3 to 6. These children are the most suggestible and impressionable, and are easily wielded as pawns, weapons, and tools by parents in protracted divorces, parenting time disputes, and custody battles. Studies have shown that it's not difficult to convince a child to say that the man or daddy touched their pee-pee when it never happened. Most cases aren't representative of malicious coaching by disgruntled parents. Most unsubstantiated cases may be the result of a lack of source monitoring by well-meaning child protection professionals, and the same results in source misattribution errors. Source monitoring refers to reviewing the credibility of the source of information used in the investigation of the child abuse allegations. The mindset of our child protection system is that children don't lie, can't be mistaken about sexual assault, and must be believed and protected at all costs. Although most children don't, some do lie, and as young as 3.5 years old. And several children are mistaken or are in error, especially when making delayed disclosure reports of alleged abuse from 4 years back or more. And CPS oftentimes doesn't conduct source monitoring or doesn't consider alternate hypotheses. They're well-meaning and well-intentioned, but sometimes misguided. They may have never considered a child's vulnerability to suggestibility, or that repeated interviews of the allegedly abused child could trigger false memories. Combine that with the hearsay rule, the fact that 95% of all child sexual assaults are negative for medical findings and trauma, and the fact that all family and juvenile court judges must rule in the child's best interest, it's easy to see that a parent wrongfully accused of child sex abuse is not an uncommon thing. More times than not, it's fathers and stepfathers who are wrongly and sometimes falsely accused of child sexual abuse. But in today's world, where judges oftentimes err on the side of caution, on the side of children, mothers can be wrongly accused too of failing to protect children, coaching children to falsely accuse the other parent of sexual abuse, and Munchausen syndrome by proxy, now called pediatric condition falsification and other things. The evidence against the accused is determined by a credibility shootout in court. It becomes a case of he said, she said, and what a child said. The child's belief system in making their initial report of abuse, and which may have been triggered by an overprotective parent, could be reinforced by a well-intended but misguided psychotherapist in sexual abuse treatment programs. In other words, it's possible the child's therapist may have treated and reinforced a child's false beliefs without knowing. Mandated reporters such as teachers, guidance counselors, doctors, nurses, and therapists are required by state and federal law to report any reasonable suspicion of child abuse to Child Protective Services, CPS, and/or the authorities. While CPS policy and procedure manuals and state statutes do make mention of false child sexual abuse reports, most child protection investigations and police officers are neither educated nor trained enough in the niche area of false child sexual abuse investigations to be able to discern critical SAID factors such as the timing of allegations, case dynamics, the young and suggestible child whose statements may appear rehearsed without contextual details, and a parent who won't accept no for an answer and who suffers from a fixed and rigid belief system. So it's incumbent for CPS, police, and others involved in alleged child sex abuse to not contaminate the crime scene. That is, the child. In other words, if 5-year-old Stacy tells her mother or her kindergarten teacher that she was touched inappropriately, only a few open-ended questions should be posed by the adult to the child. For example, Stacy, can you tell me what happened? Can you tell me about that? Can you tell me more about that? The government's investigative agents will conduct a forensic interview, and she will be questioned and video recorded. The child forensic interview should be conducted, as should the anogenital rape examination, if necessary, within 3 days of a child's report. There are only about a half dozen jurisdictions in the United States that employ the evidence-based best practices child forensic methodology known as the NICHD, which stands for the National Institute for Child Health and Human Development, located in Bethesda, Maryland. It published its first study in 2000, and it opined the best method to extract spontaneous, reliable, and trustworthy statements from a child interviewee is to ask him or her open-ended questions. The NICHD is a fully structured protocol that avoids leading, suggestive, direct, repeated, and negative stereotype-inducing questions which can taint and distort information from a child. Other methodologies are semi-structured methods that allow the use of questions to a child that can taint the interview. Oftentimes, in cases of alleged child sexual abuse, CPS will recommend the child victims enter into sex abuse treatment programs. Relative to young children, this equates to child-centered play therapy. Play therapy entails the child playing with anatomically detailed dolls, puppets, drawings, and sand trays. The problem is, this well-meaning psychotherapy can be misguided as it potentially treats a non-abused child as a sexually abused victim. And that's tantamount to a child receiving chemotherapy or radiation before a lab or physician has diagnosed a child with cancer. As in medicine, psychotherapists should first do no harm. They can trigger adverse child experiences, or ACEs, in children. How to defend against false accusations of child sexual abuse. When a person is accused of the unthinkable, child sexual abuse, that person is presumed guilty until proven innocent. And while this maxim is against what's recognized in our Constitution, this is the allegation of child sexual abuse. Next to murder 1, the allegation of child sodomy or capital sexual battery of a child is the worst an accused individual can face. So how does a wounded innocent accused of child sexual assault prove a negative? If you're a targeted parent and victim of parental alienation as a result of false or unfounded abuse allegations, please consider the following recommendations. Always place the needs of your child ahead of your own. Neither vilify nor denigrate the opposing parent or alienator or false accuser in front of your child. As painful it may be, foster and nurture the relationship of your child with the opposing parent. There are few attorneys who specialize in the litigation of false abuse allegation cases, and so be mindful of that when vetting attorneys to represent you in court. Don't wield your child as a pawn, weapon, tool, or messenger in your protracted child custody case. Don't delete your emails, text messages, messages on a parenting app, or any posts on social media authored by the opposing parent, as they can be used as evidence in court to help prove or disprove parental alienation. Keep accurate records of by whom, when, and how many times your child was informally and formally forensically interviewed. Don't talk to CPS or the authorities without counsel present. If you do speak to CPS or the police or any governmental agent for the state, be courteous, not disrespectful. Don't submit to a police polygraph. Don't answer your cell phone if the caller is unknown, restricted, or private, since it could be the authorities conducting a confrontational call to try and induce you to confess to something you didn't do. Create a timeline or journal by dates and events in the word processor of your computer. Save your resources because competent help in this area of law is sparse and expensive. The accused should voluntarily submit to a psychosexual risk assessment from a psychologist. This includes a mental status examination, clinical interview, and a day of psychological psychosexual testing. The gold standard child sex test is known as the ABLE assessment for sexual interest, and if it's an SAID case, you'll want to take the AASI-3. Find it at www.ablescreening.com, which screens the accused with the dynamic of a divorce and custody battle. Experts are looking to see if the accused shows sexual interest to prepubescent children in an SAID case or not, and what his cognitive distortion scale turns out to be. Cognitive distortions are justifications that genuine pedophiles or child molesters employ to try and beat the rap. We're looking for a cognitive distortion scale less than 25%, closer to 10% for an individual who's not trying to hoodwink everyone. Other scales from tests can depict a psychopathic, deviant individual who's lying and defensive. Other experts may be necessary for the accused and his or her lawyer to opine in the areas of anogenital rape examination studies, cognitive developmental child psychology, child suggestibility and memory, proper handling versus mishandling of child protective investigations, and de facto psychotherapy of alleged child victims of abuse. In these cases, the best defense is an aggressive offense. Let's consider the CPS child abuse investigative findings. By and large, statistically speaking, only 5% of all child sexual assault reports that are investigated by CPS in the U.S. are false. A definitional distinction between false unfounded or unsubstantiated is necessary to show the differences between the two. A false abuse allegation is one that's made in bad faith with malice aforethought and is premeditated to hurt the falsely accused party. Few states make it a felony to prosecute false abuse accusers, and perhaps more should. An additional approximately 70% of all child sexual assaults that are investigated by CPS are unsubstantiated, meaning child protective investigators couldn't meet the burden of proof of preponderance of the evidence. There exists a gray area within CPS policy and training manuals, nationally known as indicated, which internally could place the accused in CPS statewide registry and database of child abusers. The accused must request through their attorney or themselves an appeal hearing before an administrative law judge in order to attempt to compel CPS to redact the indicated finding. The burden of proof at the appeal hearing before the administrative law judge is on the accused and by a preponderance of the evidence. Written by Dean Tong and produced by the Law Center. Click the link in the description portion of this video to learn more about them.